Good afternoon, everyone, and welcome to today's webinar, How to Build a Rock-Solid TCPA-Compliant Outbound Campaign. We're glad you could make it. Okay, why don't we get started? Hello again. My name is Lynette, and I'll be providing hosting support today for our two presenters, Rich Hamilton of AnswerNet Compliance and Michele Shuster of McMurray & Shuster. Thanks for your patience. Just a few things before we get started, just a few housekeeping issues. Please, you came in muted probably, but please keep your mics off on mute for now, just to eliminate some of the background noise. But if you do have questions during the discussion, please use the Q&A feature. And we will have a Q&A session at the end, but feel free to send your questions throughout the presentation as they come to you. We do have another co-host looking for your questions, and Rich and Michele are going to keep an eye on those as well. So getting started, let's let our presenters tell us a little bit about themselves.
Hi, I'm Michele Shuster. I'm managing partner with McMurray & Shuster. And Rich, I have to tell you, it is such a pleasure to be presenting with you today. I think we have known each other, I tell you, it seems like going on 20 years at least. And this is the first time we've given a presentation together, so I'm very excited about that. So my background is I have been practicing law for 30 years now, which is hard to believe since I'm only 31, but that is possible. And I've spent pretty much my entire career in this field of direct-to-consumer marketing and advertising, and really, focusing on those communications that go across phone lines, emails, text messages. Former consumer protection chief from the Ohio Attorney General's office. So while I didn't set out to become a telemarketing attorney, when I was in the AG's office, the do not call laws were being enacted. And so when I left, I was pulled in by Big Law to help companies figure out how to put together compliance programs to meet all of those new regulations that we had just passed. So it's a pleasure to be with you today, and look forward to sharing with you all of the exciting updates that are going on right now.
Awesome. Thanks, Michele. That was great. So I'm Rich Hamilton. I'm the Director of Compliance here at AnswerNet. Yeah, Michele, it hasn't been 20 years, but maybe close to that. And yeah, that's crazy since I'm only 27. So if we're going to use those kind of years.
Yeah.
I've been in call centers as an agent since I was in high school, and just moved my way up. And then at one point, all of a sudden, I was getting dragged into compliance work and started doing that over 10 years ago. So it's been a while that I've been in this space of it. It's nice because I understand the other parts of the business from running call centers, but now I'm trying to tell our operations and sales and others what they need to be doing, along with the great sales techniques they're using, but they need to be compliant as well. So I've been doing, at this point in the last probably 5 or 6 or more years, have been helping large companies and small companies to either create or enhance their telemarketing compliance program. So yeah, I'm excited. Michele really is here to keep me on track and make sure I say what's right. She's my fact checker, so she may jump in if I say anything wrong. But yeah, to get started, as I've gone through helping a lot of these companies with their compliance programs, I found that there's been a lack of a full understanding of the laws and how they can use them to apply to their outbound campaigns. So my goal here was really to try and come with a set of instructions, a checklist, if we want to call it that, of what we can do to make sure that we've got a nice, rock solid outbound campaign that's compliant focused. So as you can see here on the screen, we're gonna talk about a couple different areas. I use the word step, but really they're not really in order. They're sort of in order, but obviously the base of this is to understand the regulations, and then we're going to jump into different areas that we need to watch for, right? Consent and how we do our scrubbing, understanding our phone leads and where they're coming from. Training is important. Record keeping is important. And then, of course, doing some regular audits. So that's what we're going to cover. Obviously, Michele will jump in as well when I say something wrong. Or, as she said, we're going to talk about some of the new things that are coming up right now in the law. So with that, we'll jump into the first one.
Rich, what you said was that I think is so interesting, and I think so important too, is when we're working with clients, and I know when AnswerNet is working with its clients as well, the really critical part of that is figuring out a way to operationalize all of this compliance that is out there now. And, it's become kind of an art to be able to tell our clients, not that they can't do something, but how they can do it. Now, they may not always like all of those steps they're going to have to put into place to do it, but I have something I've always appreciated about AnswerNet and the way that they work with their clients as well.
Yeah, that's very true. And I think a lot of it comes down to sort of that risk mitigation, right? It's really hard to say that I'm 100% compliant, right? And I will never tell a company 100% compliant, I'll get you there. Because there's some risk always. And so it's really about how do we mitigate that to a level that's comfortable for each client, right? So some are really risk adverse and some are not.
Yeah. We call it creating a defensible position, and creating that defense about levels of risk and what the result is if the worst possible thing happens with that risk. So it's probably the most important thing as you're thinking about compliance with your company, understanding the requirements and the risk and the potential outcomes. So hopefully we can help you with that a little bit today.
Yep, exactly. Thank you, Michelle. Okay, so the first step or the first area we're going to look at is just understanding the regulations, right? So really baseline, we need to make sure that we familiarize ourselves and anyone that's going to be involved, right? The sales teams, maybe operations teams, understanding what is the Telephone Consumer Protection Act, right? The TCPA. This is enforced by the FCC, right? So understanding that law, probably even being able to read through it. The telemarketing sales rule, which is enforced by the FTC. Again, being able to read through that, they actually, what I love about the TSR is they have a really great website with an FAQ. It really spells out very, very well. I wish the TCPA had something a little bit better. The TSR is fantastic, so you can really get some good detail on their website. And then of course there's the state specific, and right, Michelle, you and I were talking about this earlier today, even that there's so many laws at a state level that it's really hard to keep track of them. And so this one's probably the harder one, is to understand all those state laws. We were talking the other day, right? You got Florida and Connecticut and Oklahoma, Maryland, that sort of have their own mini TCPAs, right? They've taken their own definitions of some of these words. And so you have to take that into account as you're creating your campaign. So, these are really important that you understand as you're starting to put together your campaign. Secondly, I point this out because consent is becoming very, very important. It's really just understanding the difference between what is, express consent versus what is written express consent, right? And there's obviously that word written is a big difference, obviously, but what does that really mean? And that's really going to become important when we're looking at what type of dialer we're going to be using and if we're going to be dialing wireless. So those two aspects really make it more important on what type of consent we have or what type of consent we need to get. And then the third under understanding regulations is just understanding some of these differences of, and we'll go through them. So sales versus informational. I've found in a lot of the communications I've had with clients that there's a little bit of maybe misconceptions of what a sales call is. And, things like an appointment setting call, right? Where you're trying to set appointments. Why? So that on a future call, you can sell them something. That appointment setting call is wrapped up into that. It would be considered a sales call. Same with, a lead generation call. So it's very important to understand and be able to categorize, okay, what kind of type of calls we're making? Is this informational? Is this a pure reminder? Or is it a reminder, but I'm also trying to upsell them to something? Whoops, now it's going to become a sales call. And of course, that just really means a change of what kind of laws you have to apply by. B2B versus B2C, we can spend some time here. This one's becoming a little bit more interesting. I think a lot of people think, oh, B2B, I'm exempt from everything. I hear that a lot. And that's not necessarily true. There's definitely some parts of the TCPA and the TSR that we have to pay attention to when it comes to B2B versus B2C. Cold call versus EBR, again, understanding, are we calling people that we have some type of relationship with, or are these maybe leads that we purchased from, maybe another aggregator or someone else? Where did we get this list from? Who are these people we're talking to? And importantly, right, when maybe did we have that relationship with them? Was it a month ago? Did they call us? Or is this an old members list from 3 years ago? I get that. I want to call these people that were our customer 4 years ago. Okay, let's look at that a little deeper. And then, of course, it's really good to understand as a company, what kind of technologies do you have, right? What kind of dialers do you have? I know here at AnswerNet, we have several different types, right? We've got manual dialers, we've got predictive dialers, we've got, the HEDS. And so it's a matter of understanding what we have so that when we're setting up the campaign, we can make sure to use the proper regulated technology, so word we like to use when depending on what the campaign is. Hey, I love these graphics. Marketing team's great. Okay, so the second area that I wanted to look at, now that we understand the regulations, I want to just dive in a little bit more in the making sure we have the proper consent. So again, there's going to be a little bit of repeat across these slides, and it's probably on purpose because I just want to nail these things home. But first is understanding the type of campaign, right, and who the audience is. So that sort of goes back to that last slide of who are we calling? Do we have a relationship with them? Do we not? Are these sales calls? Are they not? This is all going to dictate what type of consent we're going to need to get, right? So we really need to understand and delineate this internally. Secondly is making sure we understand where these lists are coming from, right? And so this will be different if it's something internal that maybe our sales team is using our website and they're generating leads that are, people are inquiring into us. That'll be one type of consent versus are we buying the leads? And well, how did those leads how did those people give their information to whoever is selling us the leads, right? So understanding that consent is going to be very, very important. If we're using or want to use regulated technology, right? So again, when I use this word, I put in here in parentheses an ATDS, right? Automated telephone dialing system, or pre-recorded message, PRM. Those are going to have different requirements as well. So again, depending on what we want to use, we'll need to make sure we understand what that consent looks like. And lastly, I think what I really wanted to make sure that is important that I point out here is understanding PEWC. And we could probably have a whole call just on PEWC and how to do that. But overall, what we're looking at is making sure that the consent language, when we are gathering that on the website, that it's clear and conspicuous, and that it has all the required disclosures. And that's where we could get into this and talk for days on exactly the step-by-step what that looks like. But it's very important. It's almost like a checklist that we got to go through and making sure we're identifying ourselves and exactly how we're getting the consent, what they're agreeing to, maybe how many calls or what type of calls they're going to get, who's going to call them, right? All these things need to be answered in that consent to make sure that we're getting that proper consent.
It's interesting. We represent a lot of companies in TCPA litigation, and this clear and conspicuous comes up pretty frequently. It's something that I think a lot of companies were looking at when the one-to-one consent rules that were set to go into effect earlier this year that were overruled by the IMC case, but the clear and conspicuous was something we were focusing on, but with the one-to-one, it made it easier because you were just going to have one consumer to one seller, and that made it really understandable. But we're back to where we were before, and I'm not saying that was good that it was understandable. I'm just saying it was understandable. But now, you really do have to look to see if it's clear and conspicuous. I get the question all the time now, is a marketing partner's list something that you can put into a consent form? And the answer is always, it depends. We have to look at that consent form and see, is it clear and conspicuous? Is it on a website that's specific to a vertical? Is it clear that the consumer understands that they're providing consent to the companies that are in that list? Is it hyperlinked, which I think is very difficult nowadays to prove that a hyperlinked marketing partners list is clear and conspicuous. So all of those things have to be looked at. And kind of a tip here for you, Rich had mentioned earlier that the FTC has a great website and they do a great job explaining the telemarketing sales rule, which is their version of the TCPA. And that is called, it's the requirements for complying with the telemarketing sales rule, or complying with the telemarketing sales rule. If you Google that, it's going to take you to the FTC's website. Great primer for what the requirements are for the TSR. But what is also great in that same kind of set of documents at the Federal Trade Commission's website is an understanding the rules of the road for internet advertising. And the reason I point to that is because that specifically deals with what the FTC, which is the head consumer protection agency in the United States, thinks is clear and conspicuous for internet advertising. And you can translate a lot of that to lead generation forms. And so it will go through, what is clear and conspicuous? What's prominent placement? Is it likely understandable and readable by the consumer? So just really encourage you to go to their website. It's in their business guidance documents, and internet advertising, I think, is the subsection that's under, but really interesting stuff. So what we've done to make these TCPA pre-recorded, and we should really say artificial voice as well. So these consent requirements apply if you're using an automatic telephone dialing system or a pre-recorded or artificial voice during your telephone calls. And so it increases really the kind of level of consent or the requirements for consent if you're using that type of regulated technology, as we call it. And this is available on our website. I think we're also going to provide it at the end of this webinar. But it's just a really easy flow chart to go through those things that Rich was talking about to let you know what type of consent you need. And so, the prior express written consent has very specific requirements, and you have to identify the seller. Consumers got to provide their telephone number. It has to be in writing. There has to be a consent not required for purchase. If you're using the regulated technology, it has to be in there. But one of the things that I see that is most missed on these lead forms is that the one thing that was clarified through the failed one-to-one consent rule amendments is the FCC really focused on the e-sign act. Right. And so the reason that's important is because the consent, both for calling folks that are on the do not call list and for using the regulated technology, it says that the consumer must provide their signature. It's got to be a signed writing. And so really important that you work with your attorney to make sure you're meeting those e-sign requirements, because it's something that we're seeing more and more in litigation. And there's ways that you can do that by providing disclosures and including that in what the consumer is consenting to. So another interesting thing is if we're using this regulated technology for informational calls, there's a prior express consent that's required. And what's interesting about that is you won't find that really in the TCPA, but the FCC has defined prior express consent as a consumer providing their telephone number as a means of being contacted, and then you're contacting them kind of within the expectation of what that relationship is or what that means of contacting them is. And the reason I say it's interesting is because the one thing that has happened predominantly this year with the TCPA is the courts have really restricted its authority through a couple of different cases to be able to interpret its regulations and the TCPA statute itself. And so it's interesting because this prior express consent definition comes to us through an order from the FCC that may not be something that is required to be followed by courts. So definitely talk to your attorneys about that if that's something that you are working with for those regulated technology informational calls. On the other side, landline, if you're not using a pre-recorded message, then that consent is not going to be required. If you are using a pre-recorded message or AI, again, if it's telemarketing, it's prior express written consent. If it's informational, it's not consent. I think nowadays, when most people are initiating their calling campaigns, they kind of assume everything's a cell phone, and it's probably the safest way to go moving forward. All right, let's go to the next slide.
Thanks, Michelle. I love that. That's so great. You did a good job on that. All right, so the next area we're going to look at is the scrubbing. So again, making sure that we understand as we set up the campaign, what this looks like. So one, obviously, this is going to depend on again the rules and the types of campaigns that we identified the first few slides. But making sure that we're looking at, do we need to scrub against the national do not call list? Do we need to scrub against the states? There's several states that have their own do not call lists, and do we need to scrub against those as well? And some of those have their own set of rules, as Michelle was talking about, that inquiry, right? That express consent. Those time frames, right? The 3 months, which is federal, may not be that same 3 months at a state level. And so it's making sure we understand those differences so that we scrub appropriately, right? Because you could either go one way and just scrub super conservatively, or you could try and really just follow the state specific, which may give you more leads to call, but it also means it's a little bit more complex to make sure you're including all those different rules. Secondly, is making sure you've got your own internal. So this is another one that's very, very important, is you have your own internal. Shut that off. Stop calling me.
So many jokes I can make right now. I'm going to refrain. One thing I'm going to say while Rich is taking care of that is Something that's interesting that has become pretty apparent over the last year is when we're talking about scrubbing against state do not call lists, a lot of the states are using the federal do not call list. And I want to mention Wisconsin specifically because several initiations of regulatory actions from the Wisconsin, it's called the Department of Agriculture and Consumer Protection, so the DACCAP is its name. And they're the ones responsible for enforcing Wisconsin's do not call laws, including lists. And so Wisconsin has a registration requirement, but only if you were calling into Wisconsin. And they know if you're calling into Wisconsin because of if you are downloading the Wisconsin area codes from the National Do Not Call Registry. And so that information is shared with Wisconsin. And if they don't see a company registered within Wisconsin and they are downloading the telephone numbers from the Do Not Call Registry, then they will reach out to you and ask you why you are not registered. And that can come with some fines and penalties. So if you're scrubbing against Wisconsin area codes, make sure if you're required to register that you are.
Thanks, Michelle. I'm sorry, I'm just popular. Everyone's calling me. They need help, apparently. I'm just kidding. Good. Okay. And so we talked about the internal list, right? Making sure you have your own internal list, right? And we need to be scrubbing that every 10 days. And then more importantly, or at least how I wanted to recap this, is that each list, each type of list has its own frequency. And so I put on here at least every 30 days. Again, this is really going to depend on the list, right? If we're doing a wireless scrub, if we're doing the federal scrubs internal, you can see here the internal's 10 days. The federal is not 10 days, it's 30 days. So it's a matter of understanding what lists you do need to scrub against, and then making sure you're setting that as part of your processes. So again, it can get more complex as maybe your lists get older. You may have to re-scrub those lists again to make sure that you're staying compliant. And I think we have another cool slide from Michelle here.
Yeah, this is our chart with the do not call scrubbing requirements. And so basically everything Rich just said is in the flow chart in front of you. So, if you are making a telemarketing call and it's to a residential telephone line and you don't have consent or you don't have an exemption, then you're likely going to have to scrub against the do not call list. The one thing I want to say about the B2B numbers, and Rich and I were talking about this actually right before we got on the webinar, and that is the uptick we have seen in litigation that it involves a company that believes that they are making business-to-business telephone calls. And they're really asking the wrong question. It isn't if they're making business-to-business telephone calls, it's if they're calling business telephone numbers, or are they calling a residential telephone line, because it's the residential telephone line that's regulated. And how we see this popping up in cases is that companies will making clearly B2B calls. These are meant to be business opportunities that are being presented to businesses. And, kind of a typical fact pattern is that the company calling got these business telephone numbers off of some type of public website. Maybe it's a registration at the Secretary of State for certain licensed professionals, and that's who they want to reach out to. So in theory, because they're making a B2B call and they're calling a business telephone number that's been held out as a business telephone number publicly, they should be exempt from scrubbing against the do not call list. But that has not stopped a lot of plaintiffs from still initiating telephone calls. The one kind of bright spot that we've seen in some of this litigation is that it's really an individual inquiry with every telephone number that was called as to whether that's a telephone number used primarily for business or residential purposes. And so one court in particular that has looked at this has said, well, in order for us to make that individual inquiry, we cannot certify this as a class action. And so, obviously as litigators, if we can keep a class from being certified, that is a huge win. And then you just get a one-off settlement, far less expensive, far less litigation. Most of the plaintiffs' attorneys lose interest in those cases at that point. So, make sure you understand if you're in a business-to-business campaign, what that really means. And do you really have a defendable position if you're not scrubbing against the do not call list that this is a residential telephone number? Because you'll need to be able to put forth some evidence, like I went to a business website and these were held out as business telephone numbers. So anyway, again, those are available on our website, mslawgroup.com. Feel free to reach out and download those.
Yeah, and Michelle, that's a great point, because back to the beginning when we talked about how it's not black and white, right? The law is there, but right, it can be interpreted. And so that risk mitigation comes into play, right? It's if your company is dialing business to business, it's, having to make decisions internally with your own legal counsel on, how do you want to approach that? Because there are some different court cases out there.
Yeah,
Very
absolutely.
good. Okay, so the next area I want to look at is just understanding the leads that we have and those phone numbers, right? So there's a couple different pieces I wanted to talk a little bit about here. One is using tools to detect the reassigned. So this is something that's newer in the last few years. There's a new database out that allows us to understand if a number that we may have got consent from, right, talking back to the PEWC, we received consent for a phone number, if that person still owns that number, right? Because if they have got rid of that number, which is happening more and more these days, it seems like, then we no longer have that relationship with that number. But it's hard to know that without either calling that number and them saying, nope, that's not the number. But now you're already in trouble, right? You're already trapped because now you've already made a bad call, or it's using a database. There is a specific reassigned number database. That's what it's called, the RND, that you can use to identify those. So this, again, depending on the type, could be very, very important. And here you can see the updated pricing for that. I'm not going to read this line for line for you, but just wanted you to see that the prices actually went down a couple months ago. And again, if you're interested, here is some of that pricing for that. Right now, Maryland is the only state that's requiring that. But again, you can also look at it from a non-compliant standpoint in terms of, we want to be more efficient with our dials, so we don't want to call people that maybe change the numbers. There's also another database for invalid numbers, maybe numbers that just were disconnected, sort of a variation of the reassigned. Secondly is wireless. So as we've seen from the different charts that Michele showed, depending on the type of campaign we have, we may want to be able to determine if they're wireless or not. And this can become important not only from what kind of technology we're going to use, but there are certain states that just do not allow calls to wireless without having a relationship or, other set of requirements. So, again, depending on where we're calling, we may need to understand if we're dialing a wireless or not. And again, this is a repeat that I think I've said before, but I think it's important, is, again, understanding where these leads are coming from. We've learned, or I have seen some court cases in the last couple of years where the buyer, right, me as the buyer, if I bought my leads from a third party, if I don't look into that closely and make sure that who I bought them from is following the law, right, and is obtaining those properly, they're going to probably get in trouble, but guess what? So am I, right? That I'm going to have some of the fault there. I didn't do the due diligence as well. And so it's making sure that, we're not just taking a company's word up, TCPA compliant leads. Right? We see that all the time, but we need to look into it as well and see how they're getting those leads and make sure that they are getting the proper consent.
I've always found that so interesting when the phone call starts with, we're calling with TCPA compliant leads. And my first question is, well, what exactly does that mean to you? Because TCPA compliance is not a one thing fits all. And I think for most of the folks that use that term, it means that we have gotten leads from this person. Therefore, we believe that that's a compliant lead, but it's always just the beginning of the inquiry, not the end with that comment.
Oh, you know what? Someone had a question. They had to correct me. Did I say Maryland? I was thinking about.
It's Maine. I think you said Maine, didn't you?
I thought I said Maine, but I may have said Maryland. I was probably thinking of, mini TCPA or so. I was thinking something else. Yes, it is Maine. I'm sorry.
It's a northeastern state.
It's over there where I don't really care. It's the other side of the country for me. So I couldn't even point it out on a map. Just kidding. Thank you for that. For someone to put that in. Okay, so next area is training, training our teams. So that there's a couple aspects I want to look at here. First one is I think it's really important, at least what I do here at AnswerNet is I make sure that my teams, not only my compliance team, but also my sales team and the operations, at least the management, that they understand what kind of script disclosures there are. This gets very, very complex because there's a federal level and then there's a state level. But I think it's really important then for them to understand, okay, here's the federal rules, right? We need to identify who we are. We need to identify what, my name, what the company is, what we're trying to accomplish, right? What is the purpose of the call? Here's my phone number, and go from there. At a state level, it gets a lot more complex, and I don't expect my teams to know that, but I do want them to at least understand that if we're going to dial in all 50 states or whatever, we need to look at what does that mean in terms of the disclosures. So at least them having at least acknowledging that, yes, there's going to be some complexity there.
Rich, do you find that most people do try to make state-specific disclosures, or do you find they're using the most restrictive or includes the most disclosures that they're using? Because some of those are pretty, like in New York, you have to tell the person in most circumstances that they can put their that before you start any kind of sales pitch, that they can put their number on the that company's internal do not call list. And so, I mean, talk about killing a sales pitch before it even gets started. So, you know, it becomes complicated, and, you know, the over 18 disclosures or inquiries, I guess I should say, or permission to continue or no rebuttal. I mean, it really is an art figuring out all of those disclosures for all of the different states. What do you find most of the folks out there do?
You know,
they do it based on area code and address.
I wish. I mean, in a perfect world, we'd have some kind of system that does that, but that gets so complex, and there's so much you'd have to review to make sure that they have all the rules in place. I have had one client that did that I was able to explain to them okay, here's the states you're going to be in, here's the disclosures, and they were able to program based on using address and area code so that their scripts displayed properly, which I found very impressive, but it took them a long time. In most cases, what I found is at least what I've suggested is maybe bucket it, right? There's, you know, like you said, there's certain states that are the no rebuttal states. So, okay, I'm going to make a script for those states so that they all cover this same disclosure they need to make. So I usually will bucket them in like 3 different buckets, you know, one that's very, very conservative, one that's not very conservative, you know, one's sort of the middle. But, you know, there are a few that they just don't even want to deal with that at all. And I'm going to give you one script and it's going to be everything. And it's tough because if you're in New York, you're going to be telling everyone in every state that they can be placed on the DNC list. That makes it tough for sales. Yeah,
that's tough for sales. Marketing would not like that. Compliance would love it, though.
We are all over that. Yep, we'll give them the thumbs up. All right, next. Flip to the next one. So something we do internally as part of that process is, you know, not only do I try and train our sales, marketing, and the operations about the script, but we ask them to take those campaigns and send them to us so we can review them just to make sure, right? Because again, I don't expect them to understand it. So this has been a best practice for us is they'll send us what they have. They have been trained, but every once in a while they'll miss something. Oh, whoops, we didn't tell them about the call being recorded, or let's make sure in this state we got to make sure we say this. So we just sort of a backup that we can just, you know, a secondary pair of eyes that we can make sure that they're meeting all the disclosures. The third one, I love these actions, is, you know, when it gets down to the agents, right? Now we're down to the agents that are actually on the call, you know, is making sure they understand, you know, some of the TCPA rules. Really what's important is for them to understand the DNC rules, right? Because this is a requirement, right? So this is when we're getting down to the actual requirements. We need to make sure that they are trained. I like to add in here that they understand how to escalate any kind of call that maybe there's a complaint, because this is where you're going to generate maybe some complaints and some problems with, you know, the FTC if they complain to them. So we want to try and take care of those in-house if someone has any kind of real issue. So I include those here as well. But really, it's about training those agents on the DNC, how we handle them, identifying anything that sounds weird. Someone saying, hey, I swear I said last week to not call me, that, you know, they understand that and think, okay, this is not good. We should have handled that properly. Maybe I need to raise my hand and talk to a supervisor and figure out maybe something went wrong. So that's very important. And then on top of that is making sure that all that training is documented. And the way we like to try and do it here at AnswerNet is making sure that this training, and I have a couple separate trainings, one for agents that's very meticulous on the DNC side. And then I have one I do for management that just goes at a little bit higher level. And we do that at onboarding, and then we do that once per year, right? So that we're covering all the changes that happen, especially if there's a change that happens more quicker, maybe we'll have a different training, but really we try and include everyone at all times so that they've got at least some basis for the compliance that's happening. Next. Okay. So I touched on this a little bit, but, you know, the record keeping, I tried to break this down a little bit because, again, this can get a little bit tedious and complex, but we need to make sure that we are holding on to these call records, which can include consent as well. So I use the word consent records, but right, with every phone call we make, we need to make sure we've got that consumer information, you know, whatever it is we're gathering, you know, the timestamps, right? When did we call them, the call durations, those types of things that are usually pretty standard within a lot of our dialers. If it is a consent, did we capture like an IP address or something of what website they were on? Where did they get that? What disclosures they were reading? The consent language. Right? Maybe a copy of the web form. This is really nice to have. I think back to Michelle's point of the conspicuous and, where is the language on the page? And so being able to have a copy of that to say, if someone says, well, I didn't do that. Well, here's what you actually filled out. And here's what the language was. It was above the button. I mean, or whatever, you can show them, or show your attorney when you're trying to show that you need to have a defensible position. This is important as well. And then, of course, the exact consent language, which may be part of the web form as well. So these are all really important to have with each of your calls. On top of that, on the next little action here, I also just mentioned some other things that are going to be important to have as part of the records, right? We want to have copies of all the scripts we're using. We're going to want to have recordings if we're doing call recordings. And again, there's some conversation you can have on how long you want to keep those recordings. The scrubbing report. So this one's really important. Going back to the slide about talking about making sure that we're scrubbing our list properly. We need to show those reports, right? We need to show that proof that we did scrub, every 15 days, every 30 days, every 31 days. We need to show that with some reports. And lastly, what I put on here is, the opt-out. So we're keeping track of that. When those opt-outs come in, this becomes very important because there's a time frame, right? There's that 10 days of getting that on the list so we don't call them. So, again, keeping track of that. So as you can see, record keeping is pretty important, right? Because it's proof that all this that we're talking about that we're doing. And, overall, we really need to make sure that we're maintaining 5 years for these records. Again, each company is a little bit different. I know at my previous work, we actually like to keep everything for 7 years, right? Because there's a statute of limitations and some things that are legal really wanted to say, okay, 7 years. And after 7 years, we're going to ditch it. We don't need to hold on to it any longer. But the requirement under the, for telemarketing law is 5 years. Michelle, anything you want to add? I feel like I'm talking a lot.
No, that's perfect.
Good.
Records are just so important, especially the consent records, because if you ever do end up in a lawsuit and you can't produce the consent or a regulatory inquiry and you can't produce the consent records, it's a significant issue. It doesn't leave us attorneys with much to work with unless there's a really good reason for that, and we have a process and procedure that we can potentially fall back on. But it doesn't leave you in a good spot if you run into litigation.
Yep. We had a question come in. I think maybe now's a good time we can read that. I'll read it off. If a company in our industry slips up, what kind of penalties are we actually looking at, and how badly could it hit our business?
Catastrophic. I guess it depends upon how big the slip up is, right? And so, in the TCPA, it's $500 to $1,500 per call. That's per call. That's not per person you called, it's per call. And so you very, very quickly get into, monopoly money type of penalties. And so, I can tell you that the overwhelming majority of these cases will settle. But when you do see the cases where companies have rolled the dice and thought they had a good defense and thought they could minimize penalties. I think Visalis is probably one of the best examples of that. I think it was $934 million was the TCPA judgment. It put the company out of business. And so, these are very, very significant. The one other thing I will say, actually, one of the folks I was talking to today is Otto Forrester. He's an insurance agent. Everybody thinks you cannot get TCPA insurance. You can most certainly get riders to policies. If anybody wants to be connected with Otto, I'm happy to give you his information, or you can look him up, Otto Forrester. I think it's a good idea to get TCPA insurance if you can. And then also just, make sure that the limitations aren't going to make it so that it's not worthwhile for you. But this is probably the most important slide of the whole presentation that we're giving about the conducting of regular compliance audits. How do you do those, Rich?
Oh, wow. Look at that. That was a great. So I'll start with just sort of a generic. So I think it's really important that we're looking at, you're regularly reviewing, right, the policies you have in place, what kind of practices you're using for dialing, the consent and how you're getting that consent, list management, right? We're talking about scrubbing, and just, how you identify these campaigns and how you set the rules. So that's really important. I say regularly, there are some things here that I'm doing on as every new campaign comes in, I'm making sure to cover and look at everything. But typically on almost at least at quarterly, I'm going to look at this at least as a something that's on my to-do list on a quarterly basis. Now, as laws come out, I'm going to make adjustments much quicker, but I want to, at least on a quarterly basis, I'm going to read through all of our policies. I'm going to check with our tech team and say, okay, what kind of technologies are we using? Did it change? Because I need to know that if things change. So yeah, regularly can be a lot for everyone, but I try and be as proactive here as possible. The second point, which is more of what I do, is maybe having a compliance partner, right? Someone that can help you. Michelle's a good option, but I'm also a pretty good option too with the cool mustache. But
I think both of us combined is probably the best option.
There you go. And I think at the end of the day, right, a lot of companies, what I've found, they will, the first thing they'll tell me is, yep, I have a legal counsel. And as I start to ask them questions about specific processes, TCPA, things like that, it's quick to see that just like internally here at AnswerNet, I have a legal counsel that I report to. They understand some of it, but not the whole thing, not very comfortable. So you can get partway with your own legal counsel, but definitely having someone that's specialized is really important. I've found that being from the outside, it's really easy for me to ask all the questions I need to ask, even the tough questions, and get those answers. And, for me, it's non-biased, right? I'm not here to catch someone or get someone in trouble. I'm trying to give a very objective approach and give you, answers, and then let you as a company decide that risk mitigation or how far or how little you want to do. That's up to you. So, again, it depends on the company and how much you want to invest in that. But this is definitely a solid option to, just having someone from the outside take a look. And third, which is what we're going to dive into now with Michele a little bit more, is, and this is where it becomes very extremely important, is, as I do any types of audits or assessments for companies, this is something I definitely offer, which is, okay, great. We're going to help you get, a compliance program set up, make sure you feel comfortable with your dialing, feel that you're not at risk. But things are going to change, right? And so making sure that you are tracking the law yourself, which can be tough, or having someone like, me or Michele, we can help with that in following those laws so that we can update our policies and processes. We can update, the definition of an ATDS changed a few years ago, and then it had the whole industry flipping out, trying to adjust what they were going to do in terms of what kind of technology to use. And this is happening every few months, it seems like, or more, where there's some kind of change that we need to watch out for.
Yeah. And it's not just regulatory or statutory changes, it's case law too. So, it's a pretty tedious process. We have an associate that is assigned with this task, and every week they're required to provide updates on any changes in cases or regulatory or statutory changes to the telemarketing and really marketing in general and privacy laws. And it's a pretty onerous task, I will tell you. Even with really great, monitoring tools that we use, it's still an onerous task.
Yeah, exactly.
So this is one that everybody has been talking about lately, and it's Texas, and it's because it has changed a state that was really kind of low in our risk profile when it came to states that we were concerned about, and it's moved it up to the top because of the changes that they've made. And one is, making registration a violation, and before the registration requirements were not very broad. They are much broader now, and it expanded, the definition of what a telephone solicitation is. I will tell you that the telemarketing laws apply to sellers, the registration requirements in Texas apply to sellers. And so that's somebody who's selling products or service on behalf of themselves. So in theory, obviously have this reviewed with your legal counsel. In theory, if you're a call center, you are not required to register, which is kind of unusual. That's not typical for most of the states. So definitely review that. And because it does come with monetary penalties now that are pretty steep, you're going to want to make sure if you're required to register that you do register. The other big change is that previously the telemarketing laws in Texas required that notice be given and some other procedural like hoops that consumers had to go through before they could file a telemarketing lawsuit. Well, those have been removed now, and the consumers, the called parties, can now file directly under the Texas Deceptive Trade Practices Act, and that comes with some pretty steep penalties, a lot like the TCPA. It lets consumers collect not just one time, but multiple times under different factual scenarios. So if they have repeat violations against a company, then it's not just that one violation, those repeat violations all kind of stack. And they've just made that very, very clear. And so, you know, this is one of those areas that you really want to make sure that you understand what's going on in Texas. We have done a lot of consulting about Texas lately. If you haven't spoken to the folks over at AnswerNet or your attorneys, you definitely want to make sure that you've updated your policies and procedures for Texas, because they have changed pretty significantly. The other one is Oregon. They've declared that a text is a telephone call. It's a telephone solicitation. I think everybody treats a text as a telephone solicitation. So when the states change, I don't think that's big news, but that is one of the changes they made. Also, you're probably aware on the federal level that the allowable calling times are 8 a.m. to 9 p.m. The time restrictions now in Oregon are 8 a.m. to 8 p.m. So an hour, you have to stop an hour sooner than you would under those federal requirements. And then a trend that we've just been seeing in the states recently is this limiting the number of solicitations that you can make during a 24-hour period. Florida, Oklahoma, Maryland, Maine, and now Oregon limit calls to 3 per 24-hour period. It's probably not a bad idea to follow that anyway. It's usually the excessive calling that we see gets consumers riled up and gets them more likely to file some kind of complaint with the regulator or, God forbid, a lawsuit. So now we've got another state to add to that list that limits the amount of calls within that 24-hour period. And then Virginia, they amended theirs as well. Just makes it easier. It makes it clear that a text message must have the ability to opt out of that through a reply. So you have to allow consumers to reply and do an unsubscribe or stop or whatever to make a do not text. To make a do not text request, which should probably be treated as a do not call request too, because of federal requirements that'll be kicking in soon. And if a consumer doesn't want to be contacted by your business, it's probably just a best practice to eliminate them from all channels that have this kind of liability. Maybe try email a few times more, which is a little bit easier to comply with. But just note that Virginia has made that change. The other area where we are seeing a lot of changes, and it's happening in rapid fashion, is that the states are passing their own individual privacy laws. I can tell you from experience, California is very active now in the cases that they are bringing and the settlements that they are getting, and they have a take no prisoners approach. So California is one of the toughest and one you really need to pay attention to. One of the things, and so these are the states, the ones in green, they're already in effect. Yellow, they go into effect in October, which I think that is Maryland, and then January is Indiana and Kentucky. A lot of states have privacy bills that are currently pending in front of their legislative bodies. And so I suspect that we could see this change pretty significantly before the end of the year. And then if you go to the next slide, it has the threshold requirements for the privacy laws. And this is important because the privacy laws will apply to you if you are have revenue that's being generated through that state, or a number of leads that are, the number of consumers that you have data for. If you exceed these thresholds, then these privacy laws are going to apply to you, and you could be a controller. And it could mean that there are some registration requirements. It could mean that you have to get specific type of consent for or provide opt-outs for how that data will be used. We have a really great privacy group here at McMurray & Shuster, and they have been very, very busy, I can tell you, doing privacy assessments lately. And there are also registration requirements. If you are a data broker, and meaning that you have data that you sell, and sell is a broader definition than you would think it is. And so if you are transferring data, that's something that you probably want to look at. It's easy to do these threshold analysis and these data broker analysis, depending upon how you're treating data within your organization. But really cannot stress enough how important it is to make sure you're on top of these privacy regulations as they're coming in fast and furious.
That's awesome.
And the one thing I didn't mention in these slides that we could mention on top of, right, the privacy registration is that there's also telemarketing state registrations as well. And, that's something that probably would come before any of what we talked about, right, in the setup. But you do need to make sure that in certain states you are registered. And again, there's a whole set of requirements and exemptions, and it's a whole ball of wax itself. But definitely it's good to be aware of that there are some states that require that as well. As we talked about Texas, there are others. So
yeah, most of them don't have a private right of action like Texas does now, but it is something that the regulators really latch onto if you're required to be registered and you are not.
Yep. Awesome. So we've got just a couple minutes before we end up. We answered a couple questions, but I don't know if there are any other questions out there. If not, I have a lot of questions I could ask Michele, which she told me I can't ask.
You know what? That means we've done a spectacular job, Rich. We have answered all of the questions throughout the presentation. But I'll tell you, I am available if anybody has any questions after the webinar. Don't hesitate to reach out to me. I know Rich would say the same thing, and he'd appreciate it if you reached out to him.
Yeah, I mean, if you haven't noticed, as I talk faster, it's because I get excited. So as I get more excited, I start to talk faster. So I apologize if you didn't hear or understand something I said, because I do get pretty excited. One thing I wanted to make sure that we offered to you, so we're going to get you out the recording for this in a few days. We are also going to have a bunch of links. Some of the things we've talked about here, we're going to put out. I put together and Michele blessed it, but we have a checklist based on what we talked about that we'll also send out that just sort of give you some reminders of the different things we talked about that you can use as you're setting up an outbound campaign. So we'll send that out as well. Something else that's here on the screen that you can scan, or when you get it, you can look at the link. But we're trying to just help out companies, because I found so many companies that don't seem, maybe they think more than they actually know, or they really are just lost and they need some help. So it's a little, takes you not even a minute to take this little quick assessment. It's 4 questions, sort of just asking you some very, very high level basic, how do you approach consent? And, one of the answers will be, whoa, I have no idea what consent is. And so answering those questions will give you a little score of where you're at, and then we can go from there. Or, you can take that information to know if maybe you need more help or not, whether it's for me, Michele, or, figuring out yourself, whatever you're more comfortable with. But definitely please take that assessment. I'd love to see, it being used, and for those to see where they're at in their company with their compliance program. And I think the last slide then is, again, our information. I was going to put Michele's cell phone on here, but I think she's pretty busy.
It's in my signature block. I give it to everybody. Yeah, I figure somebody needs to call me. They need to call me. Yeah.
Very, very true. Very, very true. But yeah, definitely, I think, what Michele said, we both love what we do, and, and love to help. And so if you've got any questions, if you want someone with a better mustache, you can send me a message. If you want someone that's just better looking, I would say Michele probably is a little bit better looking. Go to Michele. But yeah, feel free to email us, call us, let us know if you've got any questions. Anything that came out of this webinar that we didn't answer right, or maybe we said the wrong thing. Maine, Maryland, it's the same to me. But yeah, please feel free to reach out. Let us know. We'll see what we can do to help you out. Hope you had. I hope this was informative. Sounds like we didn't have any more questions. So I think, Michele, we're right. We did a great job, apparently, and answered everyone's questions.
Defining reality is important. Thank you so much for having me today, Rich and AnswerNet team. You've made this very easy, and it's been fun. Thank you.
Yeah. And thanks, everyone, for joining, and everyone have a great day.